Okay, this is This is 140-160 class, and we're starting with a review of some of the briefs and phrases that we've been learning recently, starting off with the briefs for words that end in the word light. Blue light, didn't do that one. It's BL though, sorry. Here we go. Brake light, daylight. Stop me if you don't know any of these, okay? Emergency light, flashlight, green light, headlight, highlight, porch light.
Highlight, H1I.
Yes. H1I LT, highlight, porch light, red light, stop light, street light. Got the difference between those two? They're similar. Stop light and street light. Okay. Traffic light, yellow light. Let's do a few sentences. Always look for his brake light. It was daylight when the accident occurred. Use your emergency light. Always carry a flashlight. I'm sure it was a green light. I saw his headlight come at me. Highlight the details for me. Turn on your porch light at dawn, dark. Stop at the red light. Turn right at the stoplight. Observe the street light. Look for the traffic light. Use caution at a yellow light. Evidence. Best evidence. BEFD, best evidence. Circumstantial evidence. SEFD, we learned it another way the other day. Whichever one you learned, stick with it. Circumstantial evidence. Direct evidence. Good evidence. Indirect evidence. Physical evidence. Relevant evidence. I will admit only relevant evidence. Counsel, do you have the physical evidence? Objection, that is indirect evidence. Your Honor, I have good evidence. Counsel, do you have direct evidence? Objection, circumstantial evidence. Your Honor, what I have is the best evidence. And now room, bathroom, bedroom. How are you hitting bedroom? ERM? Wait.
I think it's on
BIRM. BIRM. Bathroom, BARM. Classroom, KLOOM or KLIRM. That's the one that you're consistently using, the IRM. So classroom, KLIRM. Conference room, KIRM. Deliberation room, DLIRM. Deliberations room, DLIRMS. Dining room, DIRM. Family room, FLIRM. Interrogation room, NIRM. Interrogation room, interview room, VIRM. Jury room, JIRM. Kitchen, KICH. Living room, LIRM. Living room. Master bedroom, MIRM. Chat room, KHIRM. Emergency room, MRM. Dark room, DROOM. In evidence, NEVD. Okay. Friday, we're going to pick up some more. do another page, but that's good for today. Oh, let me use some sentences with these. Okay. Is the bathroom connected to the bedroom? You may rest in the break room. Arrive to your classroom on time. The conference room is in the corner. Jurors report to the deliberation room. All conversation among the jurors must be held in the deliberations room. Let's eat in the dining room. Let's gather in the family room. The witness was taken to the interrogation room. He, he reported to the interview room. The jury room is on the 3rd floor. It is a galley kitchen. The evidence was in the living room. There was a slider in the master bedroom. Be wary of the chat room. Take him to the emergency room. The knife is in evidence. There was no light. It was a dark room. It doesn't make sense because this brief is for one word, dark room, not 2 words. You get the point.
Yeah.
Okay, this is 3 voice material, and we have 3 parties, 2 attorneys, and the court. No witness. Okay, so the plaintiff, oh, hold on. I have this turned on. Very strange. There we go. Okay, so plaintiff is actually going to be right there. Okay, that's plaintiff attorney, and that is Mr. Parrish, defense attorney, Mr. Flaherty, and the court. Parrish, Flaherty, court. Parrish, Flaherty, court. Flaherty, Parrish, court. Parrish. I'm doing this more for me than you. Get it in my head. This is not counted. So, and this is a proceeding called an order to show cause. Okay, so I think it is, although it's not titled that. I have it on my file as that. Oh, okay, yes, it is a order to show cause. So basically, they're going to be presenting evidence that is going to allow the court to enter evidence into a case. Okay, so order to show cause is often referred to as an OSC. So we're starting with the court, and here we go. This is the matter of Vaz versus Allegre, 256357, order to show cause, originally filed February 15th, 1995, and amended, filed April 6, 1995. Counsel, please state your appearances and that of your clients. Yes, Your Honor. Michael Flaherty, appearing for the defendants, and present in court today are Frank and Gary Allegre. May it please the court, Your Honor, William Parrish, on behalf of the Vaz family, Phil Vaz, Perry Vaz, and Peter Vaz are personally present in court today. Very good. Gentlemen, Just so you know, I am acquainted with Mr. Allegre Sr., just having met him a couple of times at social functions. He may not even remember meeting me. Thank you, Your Honor. All right, I have Mr. Parrish, you filed a response, and in part to that, the extent it demurs, the demurrer is not timely. I suppose, Your Honor, if I may clarify the demurrer, this trial brief was prepared, as you may see from the date, long ago. The demurrer has already heard, and all reserve on a motion for acquittal, a motion for judgment until conclusion of the petitioner's case. All right. I would like to put some objections on the record to the declarations if the court's inclined to accept or consider the affidavits of Gary Allegre or Frank Allegre in this action. Before we went on the record, I want to make the record clear. Before we went on the record, I had been looking at another OSC, and I suggested to counsel that we could just hear it on the affidavits, subject to cross-examination, because there wasn't much disagreement in the affidavits. And Mr. Parrish seemed a little excited at that prospect. And then as we talked further, I realized I was on the wrong OSC. So while it is still a suggestion, but it would take the agreement of both parties to do that. And if you're not inclined to do that, the court isn't going to do that. Very well, Your Honor. I take it you're not inclined to. That's correct. All right, Mr. Flaherty. Thank you, Your Honor. If I may make a brief statement, Your Honor, as Your Honor is aware, from having reviewed the file in this matter, this proceeding arises from what was a stipulated permanent injunction entered into between these parties several years ago, and the injunction arises out of what was an increasingly bitter dispute between these two families. These families, and particularly the children who are now adult, have known each other virtually all of their lives. The Vaz family and Allegre family operate competing trucking companies, and as a result of a business dispute in the early 1990s, acrimony arose between them, culminating in the beating of Gary Allegre by Peter Vaz at the Twin Arbors Athletic Club in 1993. That incident did not end the hostilities between the families, and consequently, proceedings were undertaken. There was a criminal prosecution. There was a civil suit undertaken by Gary Allegre and Allegre Trucking against the Vaz family. The criminal prosecution was dismissed. The civil action is still pending. And at or around the same time, the instant proceeding was instituted as a result generally of the same facts. And those facts were the continued threat of violence and hostility between these two families. The proceeding was resolved by stipulation, and that stipulation operated to enjoin these parties from a variety of acts directed at each other, including threatening, striking, or making any physical or verbal contact, telephoning, blocking movements, and requiring the parties to stay at least 500 yards away from each other. That stipulated injunction went into effect in June of 1993, and since then, Your Honor, there has been a continuing, unrelenting pattern of harassment, taunting, public humiliation of the Allegres by the Vazes, incident after incident after incident. Many of the incidents that are alleged in the OSC petition were in fact by anonymous parties, others were not. And we believe that the evidence in this case will show, and much of that evidence is admittedly circumstantial, that the Vaz family has indeed violated the stipulated injunction in a variety of respects. And those incidents include threatening conduct. They include sending materials through the mail. They include taunting the Allegres in public places in the Lodi area. A whole host of acts and omissions for which we are asking this court to hold the Vazes, or certain of them, in contempt. In the event this court decides not to, that is that this court is without sufficient evidence to so hold, we will be asking that the injunction that is in place be tightened up, that is made more restrictive, so that the kinds of incidents that the Allegres had been subjected to in these past many years be more effectively enjoined than has been the case previously. I will be calling Gary Allegre, Your Honor, who will be testifying to a variety of incidents that have occurred over the course of the last several years. And as to certain of these, it will be his testimony alone upon which the proof will be made. However, Mr. Allegre will also testify that at a certain point in time, and because he found himself in the position of not only being harassed, but being in the position where it was his word against others, at my suggestion, he started carrying a camera in his car. And as a result of that, he was able to capture certain of these incidents on film, and we will be offering those photographs into evidence. Also testifying will be Frank Allegre, who will testify to certain of the incidents in question in this action, including incidents where Mr. Allegre, attempting to dine in public with his family, has been subjected to a variety of harassive acts by the Voss family, such that he finds himself unable to comfortably attend public gatherings in his lifelong hometown. Finally, testifying will be Detective Joe of the Lodi Police Department, who has taken police reports on a variety of these incidents, has interviewed certain of the members of the Voss family, as well as the Allegres, taken reports and participated in the administration of a lie detector test for Gary Allegre. And Detective Joe will be testifying to things that were said by certain of the parties and his conclusions. Based on all of that, Your Honor, as I suggested, we are going to be asking that the Voss family and certain of them be held in contempt of this court, and in the alternative, that the injunction be made more restrictive by this court. Okay, did you wish to make an opening statement, Mr. Parrish, or do you want to reserve? I would like to make an opening statement at this time, Your Honor. Thank you. May it please the court. I would like to talk what this case is not about first before we talk about what it is about. This case is not about whether or not a fight occurred between Gary Allegre and Peter Voss in February of 1993. That matter is the subject of a civil suit. It is not within the order to show cause. There are significant questions in that civil suit of self-defense, and the criminal action that arose out of it was dismissed because there were serious questions regarding self-defense. So this case is not about whether or not a fight occurred. This is solely quasi-criminal in nature about the allegations contained in the amended order to show cause. There is nothing before the court to modify the terms of the injunction, and we object to that on the basis of due process and lack of notice. I would like the court, or to bring to the court's attention, our objection to the attempt to introduce any lie detector evidence. It's clearly not admissible under California law, and we raise that objection at this time. We move to exclude it. Also, the fact that police reports were made are hearsay, and we will be objecting on the hearsay basis of them at the time that an attempt to introduce them is made. That's the preliminaries. What this case is about is that action arose and was brought by the Voss family. The Voss family sought an injunction to protect themselves against the systematic and calculated harassment by the Allegre family, carrying out a vendetta against them that's continuing to this day. As is normal in many of these actions, a stipulation was entered into of mutual injunction, and what that mutual injunction proved is that no good deed goes unpunished, because by entering into a mutual injunction unwittingly, the Voss family gave the Allegre family yet another means to continue their harassment of the Vosses. That harassment in this case constitutes bringing what in all candor can probably be characterized as a frivolous motion before this court. We're here, for example, on allegations that anonymous phone calls are being made to the Allegre family. By their own admission, they don't know who, but they sure would like to blame the Vosses for it. We are here because the Allegres claim that someone anonymously, in their own definition, sent various materials to the Allegre family. We're here alone because the Allegres blame the bosses on nothing more than pure speculation. We're here on allegations of a quasi-criminal nature that are so minimal. Not only didn't they occur, but even if they did occur, do not violate the injunction by any terms, but because of the ease of pleading, allow the Allegres to continue to harass the bosses by dragging them into court and by causing them to incur attorney's fees. At the conclusion of the moving party's case, we will move for acquittal on this case and alternatively for judgment. I think the court will know on the basis of the evidence that this is nothing more than the Allegres continuing a vendetta against the bosses and will so find. Okay, well, there are two preliminary matters, and I mention them now only because it may save us time later. First is the under 351.1, results of a polygraph exam, offer to take a polygraph exam, requests to take a polygraph exam are all excluded. All right, so there will be no evidence regarding the polygraph. And the second thing is that in the respondents, easier to characterize them as respondents rather than plaintiffs, the Voss family, they raised the issue of the statute of limitations as to count 4 of the order to show cause, the 93 action. And it does appear to be well taken. I'm not ruling, well, let's resolve it before we get into evidence of it. All right, I think that is well taken, counsel. Do you want to address that? Only to say, Your Honor, that defense was raised by demurrer and rejected by the court, and I have not had an opportunity to look at or brief that issue since then. Your Honor, on that issue, no opposition was submitted in the memorandum of points and authorities. The petitioners never addressed the issue of the statute of limitations. We had a decision when the demurrer was overruled of either going in and asking the court to reconsider or simply raising at the time of trial court. I think it is properly between the court, before the court, as the court recognizes. It's been more than, maybe I'm missing something here. There was a demurrer that was sustained and an amended OSC filed. Was there a demurrer following that? Yes, there was, and it was overruled in its entirety, Your Honor. All right, but the issue regarding the statute of limitations was not addressed by the petitioner. We have a clear 1-year statute of limitations. The events are declared to have occurred outside the statute of limitations, and I agree with the court that to properly expedite this, we ought to resolve it right now. All right, I guess I should have just sat down and read this thing cover to cover. I keep piecemealing it. By the time I'm done, I'll have read the whole thing. I don't find the demurrer. That must have been the demurrer to the original or the demurrer to the amended. I don't find the demurrer to the amended. Your Honor, if I may approach the bench, I have a copy of the defendant's opposition to plaintiff's second demurrer. And simply by leafing through it, you'll see that the petitioners never addressed the issue of the statute of limitations. It doesn't. The fact is oh, here it is. Defense was asserted by way of demurrer and the demurrer was overruled. But that has no binding effect on this court, and that's just that argument has no point to it. Well, there's more than one way to get at it. Even it's just court can grant judgment on the pleadings, I guess, if it comes to that, and that's really, I guess, what I'm proposing. Your Honor, at this time, I'd make a motion for judgment on the pleadings as to count 4 as being barred by the statute of limitations contained in California Penal Code Section 802. Do you want to address that, Mr. Flaherty? I really do think it's well taken. Your Honor, I concede that the incident alleged occurred more than a year before the application was filed. Court grants judgment on the pleadings as to count 4 of the amended OSC Ray contempt filed April 6, 1995. Thank you, Your Honor. That was 15 minutes straight.
Wow.
Okay, a couple things I wanted to put on the board that you probably have not heard of. Oh, I should have marked the first one. Second one is demur. I want to talk about demur. Are you familiar with these family names?
Yes.
Yeah. Good morning. Okay, so a demur, this is the document, this is the noun. A demur is allowed in civil cases. It is one of the ways in which someone who has been sued, so it's the respondent, has several ways that they can respond to a complaint. One of them is a demur. Okay, they use it as a verb also. We demurred. Is it hard? And without looking at my notes, I forget what a demur attacks in the complaint. I think a demur, is trying to prove that there's something not legally sustainable about the actual complaint. So there's problems with the complaint. It can't be upheld, and therefore we're filing this demur. Oh, instant proceeding came up. Anytime you hear the word instant in legal matters, it refers to the issue at hand, the one that's presently being tried. So it wouldn't refer to something that occurred previously. It's the instant case, oftentimes you will hear, or the instant judge, the one hearing the case right now. Okay. I just scoot on over because the light is going to come. And I'm going to stop share. No, I don't want to do that. I just want to close this. So, close that. Stop share. Okay, we're going to work on some two voice now, and I like to start on cases and then just keep reading through them. You know what? We're going to finish this up real quick. It's the infant delivery case. So this is not counted. Let's go ahead and finish this up for her because there is some exchange in here now. How was the speed on that last one? Okay, good. Here we go. We can read the question. Okay.
Okay, for the record, no, please explain the difference.
Well, how can I best explain this to you? If I walk over to you and pinch your nose and hold your mouth closed like this and let you breathe this way for the next week, you'll be suffering from hypoxia. In other words, you're not getting enough air, but your asphyxia, I'm going to close off everything, okay?
Uh-huh.
Now you got the difference?
Yeah.
Okay, I think what becomes obvious after you look at the post-mortem examination is yes, this baby did have chronic hypoxia, centrally type stuff, so that eventually it ended up with central pathology, but chronic hypoxia was, who knows what it was due to? I don't. I mean, obviously the placenta didn't work well, but I don't know why it didn't work well.
Okay.
I didn't examine it. I don't know that any was there. I don't even know if there was a placenta examination, and even if there was, it may not explain why the hypoxia existed.
Is that type of exam kind of a common occurrence, or would it be a rarity?
What is that?
The placenta examination.
It's not a rarity. It's examined fairly frequently.
Okay.
The thing with this one is, if I remember correctly, and again, I didn't take care of this baby. If I remember correctly, there was some atelectasis present with this baby, wasn't there? That's spelled Atelectasis. I mean, one of the lungs was collapsed, or a part of the lung was collapsed. So this baby was not only suffering from central depression, this baby had a collapsed lung that it wasn't breathing from. And again, I don't know why, because again, it's not my examination.
Okay, let me just kind of ask some questions concerning the shoulder dystocia.
Dystocia.
Is there less of an opportunity for that to occur through a C-section rather than a vaginal delivery?
Well, you can get shoulder dystocia. That's possible to get in a cesarean section, but I don't think that I've ever, well, I've seen it, but it's not really a problem.
Okay, so the opportunity would be less through a C-section rather than.
Oh, yeah.
Okay, and in cases involving this during a vaginal delivery, would it result in kind of an extended period of time or an extra long time in the birth canal?
I guess I understand your question. Why don't you go again at me?
Okay, when this shoulder dystocia occurs, does it result in being an extended period of time in the birth canal?
My answer is yes.
Okay, I need some clarification. What is the birth canal for an extended period of time? Maybe my next question would kind of clear it up. What I'm trying to get at is, if that was the case, being in the birth canal for a little bit extra length of time, could it result in the asphyxiation of the child? That is, I think you can kind of see what I'm asking.
Well, I think first of all that you have to consider that the diagnosis dystocia would be commensurate with an increased period of time in the birth canal, okay?
Okay.
That would be just hand in glove.
Okay.
Secondly, the pathology report does not substantiate a type of pathology commensurate with acute asphyxia, but rather chronic hypoxia. The PATH report tells us this hypoxia occurred some 5-6 days prior to this lady going into labor, not during labor. That's the advantage of having a post-mortem examination. We don't have to guess about the questions you're asking.
Okay.
I suppose you could say that this baby could sit in the birth canal. If it sat in there for 15 minutes, there was nothing in the pathology report that showed acute hypoxia, then it didn't cause any damage. But if it sat in there for 1 millisecond and there was damage, so I don't know what is important except what showed up on the baby's pathology report. What showed up was chronic hypoxia, which was prior, rather than hypoxia from the present episode.
And I think you testified that could have been from anything.
I have no idea, right?
Could that, now you have to, pardon my ignorance, if these questions seem a little off base. It's because I have no medical background, so.
I used to have a chairman of the department who would pull that on the residents when all of the time he had written the book on it. So I'm very leery of people telling me that.
Well, this is definitely not that case. Could a condition of toxemia during the pregnancy, could that have caused that condition a week prior to the delivery?
The answer is yes, I suppose it could.
Okay.
Again, you would have to go back and examine the placenta. I think the answers to your questions are there somewhere if you take a look at the placenta.
Okay, I think in the initial intake in the outpatient department, the patient admitted to the use of alcohol, some marijuana use, and crystal methamphetamine during the first part of her pregnancy. Would that have any significance as to the outcome of the child as we have in this case? You know, you're asking for an opinion that's speculation.
Okay, the answer is yes, probably could be, maybe.
Okay, but on the other hand, it could be no also?
Sure.
So you really just don't have,
I don't.
okay.
I mean, I don't think, I know what you're fishing for, but I don't think you're going to catch one because unless there is something specific in that placental examination that points to information that's going to be of some sort of value, And if it is, it's there as a matter of record,
Yeah, okay.
not something that I testified to.
Okay, well, let me ask you some, let's see, would there have been any medication given to Rachel Post during the time in the hospital that would cause her to be positive for a urine that contained opiates?
I'm not sure. Do you want me to try to answer that?
I don't want you to answer.
That's my answer. I don't know.
Could Demerol account for a positive urine test? Would you know that if she were given Demerol in the hospital?
Yes.
Okay, so based upon what you've told me, there would be nothing that you knew of that this was going to be a high-risk delivery, that all signs indicated until the time you came up there that what Dr. McGill or Dr. Gill told you there was no problems.
Yes.
Okay, toxemia is a condition that would indicate a high-risk pregnancy.
Toxemia?
Yes.
Yes.
Do you have any knowledge that there was any toxemia involved?
I was informed that there were no complications.
Okay, so you would have no knowledge of the sonogram done a week before the delivery or anything of that nature?
No.
Okay, thank you very much, doctor, for your time. That's all of the questions I have.
Actually have the exhibits with this. Kind of interesting. Actually, this would be good to read too. This is the pathology report. Save that for next week, since we've done that whole case just about. At least this part of it. Okay. Moving on to some two voice now. So what do we do? Two every 17. Okay, so this will be a shorter segment. And this is actually a coroner's request. So the coroner is questioning a witness. So that's two voice basically. Okay, and we're gonna start here.
Okay. All right, for the record. Mr. Burris, why don't you step up and be sworn, please? If you would take the witness stand for me over here, I am going to assume that you don't know anything about an inquest and tell you just a little about the process. You are in a California courtroom testifying under oath. The purpose of this inquest is the death of Ronald Riley. The issue is whether his death is a suicide or due to natural diseases. The law requires that the medical examiner determine three things. One of them is the cause of death, the other is the circumstances surrounding it, and the third thing that we are involved in today is the manner of death. The manner can be natural causes, suicide, accident, or homicide. That is what the issue is today. Since you are testifying under oath in a courtroom, you want to listen very carefully to the questions, don't guess, answer truthfully and to the point. If you don't understand a question, ask that it be repeated. Also keep in mind that the inquest is not in a court of law. It's an inquiry into a death. Nobody is being accused of a crime. You are not on trial. We are interested in what happened to Mr. Riley.
You want assisting details and helping figure it out?
Yes.
Okay.
First, would you state your name and home address for the record?
My full name?
Yes.
Brian Keith Elliott Michael Burris III. My address is 9970 Geary, apartment number 47, San Francisco, California, 94109.
You knew Ronald Riley?
Yes.
For about how long had you known Mr. Riley?
A little over almost 14 years.
14 years. All right. You knew that Mr. Riley died in the city on or about July 4th.
Correct.
Did you know that Mr. Riley had a disease or an illness?
Yes, I did.
And is it my understanding that you were roommates or you lived together
I was his lover,
for about how long?
11 and a half years, almost 12 years, 12 years total.
How long has Mr. Riley been ill?
Mr. Riley was diagnosed with AIDS, full-blown, almost 5.5 years ago.
He has been treated, I understand, at Ward 86 at San Francisco General Hospital.
That's correct.
Among other places. Mr. Riley apparently has had a lot of problems with his disease, but I am curious about a couple things. First of all, are you aware of any abuse of street drugs or illegal agents for Mr. Riley?
An occasional bit of methamphetamine is the only one I was ever aware of. He didn't use alcohol except for an occasional beer, not even a glass of wine with dinner. That has been quite a while ago to my knowledge.
Okay, the illness that he has or had, was that getting progressively worse?
Yes, within the last month, he got much worse. He started wasting syndrome. He started becoming confused easily, and he was getting dementiated and forgetful, clumsy. He fell often. I had to watch him 24 hours a day, which I did.
Was there ever any question of injury? Did he fall or cause injury to himself?
About 2 weeks before he passed away, he was in the bathroom and he stood up too fast, and the toilet and the bathtub are very close together. He turned this way and fell into the bathtub. He had had a bed sore spot on his rear end that had gotten, started to deteriorate a little bit, but he bruised that severely, and I did have to look after that pretty closely because it got pretty bad toward the end.
I take it there was no change in his level of mental activity and so forth?
Oh no, he was sharp as a tack.
What kind of medications was he taking?
Oh my, the list is like,
Quite large.
it's an extensive list.
How about specifically the drugs oxycodone or amitriptyline? Amitriptyline most typically would be known as Elavil.
Nortriptyline?
It's generally metabolite, although it's available.
Right.
The reason for the concern is he has those two drugs in therapeutic or higher than therapeutic levels.
Which two drugs?
Oxycodone and nortriptyline.
Oxycodone, which would be Percocet.
Percocet, nortriptyline can be sold under several different trade names.
I know at the end, after speaking to his doctor on the phone, Walter Howard at Ward 86, and Mr. Riley was starting to have a great deal of pain. He had just had a transfusion. Medications were delivered by a volunteer through the service. These were left on a door handle. Mr. Riley never got the medications. He went through a great deal of pain for several days, and his situation got much worse after that. And when I got the medications and called his doctor as far as the administration of them and what levels, because he was in a great deal of pain. I mean, he suffered from neuropathy. Basically, a breeze couldn't blow and he wouldn't feel it. I asked his doctor what to give him. Then I also at that time told him I could tell Mr. Riley was not probably going to make it through the next couple of days. It was getting to become very obvious.
Okay.
And he had suggested that we get PO morphine, which is oral morphine. When Mr. Riley passed away, the person delivering it got there after he passed away.
So the Roxanol is not something Mr. Riley had ever gotten?
No, the bottle and the container were given to the person who came to the home. The paper hadn't even been torn from the pharmacy yet.
That was the first prescription for Roxanol he had gotten.
Yes.
You mentioned he was in quite a bit of pain. This was generalized or systemic type pain.
He was very achy. PO, the initials PO lowercase with periods, that means orally. You probably know that. Do you see prescriptions? Yeah, a lot of times that's something that would be on a prescription. Where did we stop? 8, 6. To this 17th, yeah. 5, 17, 17. Okay, we are going to do just a couple minutes now because we've done all kinds of crazy stuff today. Nothing too normal. So we're going to do a little bit about the with this. Have you ever looked up interrogatories as a brief? I think I can probably do TROGS, TROGS, interrogatories.
That's what I would guess. I don't know if it's 10.
I don't either, but it works, and I don't think it's anything else. Okay, so we're going to read a few minutes with the,
They have it as the end sound, and OIG.
Oh, yes, the SPW.
Yeah.
oh, what's Sandy?
And then OIG.
OIG?
Yeah. Like,
And OIGs?
You said trucks.
Yeah.
Yeah.
Oh, it's there.
Yeah. Yeah. Two plain numbers over 15 seconds, so we're going to do two plain numbers, not circled. So the evens in 14s. So let's start here, set the watch there. 14s, even numbers.
For the record, did you make any changes on them at all?
No, I did not.
Were they correct?
Yes,
Did you understand that when you signed the interrogatory responses, deposition, Exhibit 7 before notary, that you were giving testimony under oath?
I don't know if it was under oath. I knew that everything that I said in there I believed to be true and signed under a notary.
And a notary is a person that gives an oath. Is that right?
Yes,
So when you signed them before a notary, you signed them under oath. Is that correct?
that's correct.
And you certainly wanted the information that you provided in response to the interrogatories to be true and correct. Is that right?
That's right.
You knew they were a document, an important document regarding this lawsuit.
Yes,
So you were making at United $300 a week. Is that right?
that's right.
And you worked from mid-November until December 11 or 12 of 2002 with United.
That is correct.
Was that in 2002?
Yes,
And then you were unemployed from on or about December 12 of 2002 to February the 2nd of 2003.
correct.
And that's when you took a job at Denny's
Correct.
on or about February 2nd of 2003. I'm looking at the supplemental interrogatory responses marked as deposition in Exhibit 7.
Okay,
Is that correct?
that's correct.
So up until that time, if you had continued to work at United Corporation, you would have continued to make $300 a week during that period of time. Is that correct?
That's correct.
Now, when you got your job at Denny's, you made more than $300 a week, didn't you?
That's correct.
So starting February the 2nd of 2003, the day you started with Denny's, you made more during that period of time than what you were making at United.
You said after I started with Denny's?
When you started with Denny's, you made more than what you made at United when you started at Denny's.
Correct.
And you started at Denny's on or about February the 2nd of 2003.
Correct.
And you worked at Denny's up until the time that you decided to move to New Orleans.
Correct.
And the reason you chose to move to New Orleans was because you wanted to be with your wife.
That is correct.
And your wife had relocated to New Orleans, to the University of New Orleans, and had gotten a better paying job, correct?
Correct.
The wages you would have made at United would have been from December, the date of your termination, December 12, 2002, up until the time that you took the job at Denny's.
Correct.
So we're talking about 6 weeks from December 12th to February the 2nd.
Yes.
6 to 7 weeks.
Around about there.
So if we said 7 weeks times $300 a week, that would be $2,100. So if you had been working at United between December 12th and February the 2nd, you would have made $2,100.
Correct.
No one had told you they were going to give you a raise during this period of time, did they, at United?
Bob Armand had mentioned to me that for the type of job that I was doing for them, I should be paid about $25,000 a year. That's what that job entailed. He was sorry that he couldn't give me that. But he told me in January, hopefully, when we turned the hotel around and showed that we could make a profit and get all our problems ironed out, that he would definitely check into paying me more money.
Did he ever say what he thought that job ought to be paying?
$25,000 a year.
Now, what were you making on an annual basis at Denny's?
23,000.
Now, did Mr. Armand ever say that he was going to give you a raise of $25,000 a year at United?
Bob Armand said he would look into getting me 25,000 a year in January. Okay, that should have been a push as well. We're going to start our case. So we only have 162 boys. And she doesn't need 140, so you're probably going to get to go early, and I'll dictate another take to her from week 11 packet, but I don't have any 2 boys in week 11. Okay, stopping the recording for the practice.